Isi ya mama kwa abasronko so e de ba Ghana politics avenue so ebusua mama ye bonra yensem. Se na no first time awhwe ya no subscribe no share no hit notification bell no so amaye. Se ensem ba political airline so ane de bi aba abedum. Ebusua mama ye nko yensem. Ebusua ene de eye chairman Wontumi eye ne Samreboi eye mining case e wo Accra High Court. Ene na the final judgment. Omo hye ne se eye 20th year July ana omo de ne final judgment ne beba. Ebusua ansa na yɛde ɛno bɛbrɛ no ebusua moma yɛn nkotie esɛm bi a ɛyɛ ne lawyer Atachia ɛka ɛyɛ ɔfile ɛyɛ application bi de kɔ ɛyɛ Accra High Court sɛ aka osiki ɛyɛ permission sɛ aka wɔbɛtumi asa tu ɛyɛ Chairman Wontumi ɛyɛ final ɛyɛ judgment na ɛba so ɛne de no asa ahyɛ da ade akɔ ɛda foforɔ ama na nka bɛba because otu kwan akɔyɛ de akɔ sa ne ho yare anaasɛ ɔkɔhwɛ ayaresa abusua ti ɛyɛ nsɛm a ɛyɛ Chairman Wontumi lawyer ɛyɛ Atachia ɛde ato dwa ɛyɛ ɛno no abusua no ne ya project da to screen ni nkyɛn ɛde ama wɔn Chairman Wontumi new lawyer Samuel Atachia seek another deferment of judgment in the Samreboi illegal mining case nti ɛyɛ Chairman Wontumi lawyer deɛ ɔsa so ɛsrɛ court ne sɛ ɛyɛ Chairman Wontumi ruling ɛyɛ date na ɛyɛ ɛnna no akomo sa so yɛ entu hyɛ da ɛma no ebusua ɛne nsɛm bi so a ɛkeka mom yɛn kotie yɛba de aka ɛbɛto amo so
sɛ wɔno na aba besom wɔno so pray court no sɛ ɔma ne brɛ ma ne nwam na ɔmfa ntwerɛ addresses no sɛ de hyetie ɛna ano ada and ja court no ka sɛ on or before 13th of this month a ɛtwa mu na wɔtwerɛ addresses no de kɔyɛ a yɛnsa ka bie deɛ nsa ka bie no deɛ wɔ mu ne sɛ wɔse nneɛma bi wɔ hɔ a ehia constitutional interpretation enti ɛbɛyɛ a court ni stay judgment na ɛba so Monday no na o stay court na judgment ɛba so Monday na wɔno court no akɔ Supreme Court over the interpretation of certain provisions a ɛwɔ Minerals and Mining Act nim emu wadaruma na yenye adesua ewo mu wei ɛyɛ bibi a ɛyɛ normal practice ɛwɔ yɛn jurisprudence mu anaasɛ wei ɛyɛ bibi a ɛyɛ alien to mo court practices and rules ni adeade
yo bra kwame da bia ya the American ne say a hard case makes good law but just so no a harder that's when the law develops. Me who say one of the things at a personal level, me kai say emrana me NCA matter no. And I'm here counsel for the second accused, the then DG, former DG for National Communication Authority no. A similar thing is here. Emma at a point, no, not the way I not try no air cono. I didn't like it. In China, it's application and call before the judge. Manchama and Yoma are ended. The first time almost first prosecution witness, I mean, who said one or two things air cono. One aja made applications now started ever. Nti nyame eyadom ema judge no ehwe because that time no near kokota tema sebio prosecution witness or the document the ba right there and there na judge say counsel, do you have any objection to the tendering in of this document through prosecution witness 1? After my court, my client's honor in open court, I could be found as a client. Documents where I'm seeing it the first time. Do you want me to raise any objection to it? Is it something that we can rely on? Is it something that is authentic? So the whole thing looks bizarre. Because even in criminal civil trial, there are no surprises. In Tibacco, now it has said immediately, for application, I mean, My Lord Justice for
Council.
Yes, sir.
Where the boy wa metwasia senkane any document be any doubt to be wa sabrana prosecution no ho na defense no so e wo ho na wo mu di asem maybe case management level kra no bi wa esese afani nyina eti asem bo.
No correct. When we say section 6 of the Evidence Act, NRCD 323, I say admissibility objections should be taken at the time the evidence is being offered.
Maybe I try section 7 here.
Section 6 of NRCD 323.
Okay. But me kind
Ghana have a friend of the Evidence Act.
But me kind is here. Says evidence decree 1975 NRCD 323 section 6. In every action and at every stage thereof, any objection to the objections admissibility of evidence by a party affected thereby shall be made at the time the evidence is offered. Shall
mandatory. Mandatory.
Yeah.
You know, me who san am said that be ade me kana you answer makasa na be late. Into why me kai standing and me friend me other lawyers no because there were other accused person and say hey before this is what I want to do because the way I know my kono ya nhwe ya yehu ni into why na aga me application me the judge na ni me buy Tuesday na sa case me here na Tuesday Thursday if you go Tuesday and upon 10 and upon 2 p.m. 4 hours into every week be an 8 hours solid into me say na me say I did not encourage me to an amount in a me 2 years. Thankfully my Lord Justice Cheba for a court of appeal judge now over the wisdom in it I make a tell me say my Lord me say oh any dim try ye yan sheni ya yan as lawyers you may be a client in trouble. Quality legal representation as you and far more no yes me far more because section 6 no I need to take an objection.
Okay,
because this is the time we are offering the evidence. Now I am not seeing the document. It's a requirement so I make me take a proper objection on the document I'm seeing the first time.
Na Bajawasaka says to every objection to the admissibility of evidence shall be recorded, ruled upon by the court as a matter of course.
Absolutely. Don't come in. I go back, no. My law is okay. Application here, there. And then he said, look, Article 19, Fair Trial Rules, may say, an accused person should be given reasonable opportunity to prepare his defense. It is one American say, my Lord, with the greatest of respect. The Constitution and the use of that word, reasonable opportunity to prepare the defense, no. That prepared defense, no, and a very broad concept. The European Union, this particular provision, no, the 1992 Constitution, you are taken from other statutes.
I call the 19 was all the idea was say one no say a person charged with criminal offense.
No, the
19.2. A person charged with criminal offense shall in the case of an offense other than high treason or treason, the punishment for which is death or imprisonment for life, be tried by a judge and jury.
2C.
2C, okay. Be presumed to be innocent until he is proved or has pleaded guilty.
Now Yenko D.
D. See, be informed immediately in a language he understands and in detail of the nature of the offense charged.
Fantastic. Now G. G, okay. Okay, G say,
be afforded facilities to examine.
Wait. Be afforded what?
Facilities.
Mm-hmm.
To be to examine in person or by his lawyer the witness called by the prosecution before the court.
Afforded facilities to examine. That word, afforded facilities. You didn't catch the court when they say Constitution using the word afforded facilities to examine. It includes documents. Facility no yet ni pankwa. It includes documents. The examination of those documents, what means for mommy to see and cast me examine? It may make us say the 1992 Constitution use of the word facilities to examine. It includes, let me know ahead of time what you have so I can do proper examination.
The mommy surprises be in court.
The mommy surprises be two. Rakwame. Me know neko. We are buying. I wouldn't say buying here strong, mighty. I buy no echo. Now I buy a keep it documents. Rakwame, what you say? I buy documents, no. And the last minute, what the other spring you on me. And also the heading of that constitutional provision, then fair trial. And
say na how was it? Fair trial, yes. Mm-hmm.
Fair trial. Now, Kwame, how can that trial be fair? And what time or you are blindfolded me? It doesn't make sense. Even though at that time the Attorney General of that time, Madam Gloria Kufu, any team ever court. Emrana me moving my application. Almost said there be minimum crimes and no there be the Criminal Procedure Act at 30 has only 2 forms of trial.
Samreboi, the whole Chief Justice in by.
No, Attorney General.
Attorney General, in any case is a case of national interest, pa.
Yes, yeah, Mami Gloria Kufu. So she was in court, she was announced just that my law lecturer, my criminal procedure lecturer, Madam Evelyn Kilson, on the opposite application. So that be Adia Mede Bano, that is not how the criminal trial system is. That be because there are 2 modes of trial. And
not just procedural, the only money defective and answer a dear bay.
No, the Mede Bano, that is not the law. Parliament, say at 30, Parliament created 2 modes of trial, summary trial and trial on indictment. Now, say a trial on indictment, they would have disclosed the documents and the evidence they have. But because it's a summary trial, the Act 30 does not give them that. And I said, no, Act 30 was done in 1960. I'm talking about 1992 Constitution. And the provisions in the 1992 Constitution. If you want me to use Act 30 as the basis to say, there is no such thing. Thankfully, the judge in question, my Lord Chebafo, saw the wisdom in what the prayer had made. If you want to look, only me arguing. But since, maybe meaning, Article 130, Article 19, 2G, in a Attorney General so can say, the American, that is not how it is, That day, make I say, make us not tell me so, but Mr. Tamaklo, you do know that Article 19 is a human rights provision. So as a judge sitting here, I have the mandate under Article 33 to enforce human rights provisions. Now, Mr. My Lord, if you look carefully at Article 132, Article 132, then there are any law.
Article 132, me come as is here.
Article 132.
But Article 132, the what one way, where an issue that relates to a matter or question referred to in a clause 1 of this article arises in any proceedings in a court other than the Supreme Court, that court shall stay the proceedings and refer the question of law involved to the Supreme Court for determination. And the court in which the question arose shall dispose of the case in accordance with the decision of the Supreme Court.
So that's it. And see, Article 132, they say 1992 Constitution, emma the Supreme Court exclusive original jurisdiction to interpret the Constitution. However, it can happen, say, a semi-pacoso at the district court, circuit court, court of appeal, and now say at the way Senator at the High Court, what I say, or even Court of Appeal. Now, a say, there is a matter going on at the High Court, Court of Appeal, Circuit Court, District Court. Now, the parties involved, but the parties involved are raising an issue. Clearly, you can see that there is a genuine interpretation. High Court and our Court of Appeal are no ace, so men to an amobia, Jinawa. Nasa system no bra yen na Supreme Court for honor. Na the Supreme Court interpretation sebi at that time no ye the bebrewo na wetugu anamo. Rakwame mekai say yen law firm ye represent Zoom Lion Auditor General charge Zoom Lion. Say Sikabia Yetuama Zoom Lion. No, it was unlawfully paid. Into say Zoom Lion surcharge and disallowance. So in the powers of the Auditor General to surcharge and disallow. But the Audit Service Act can say Obi is dissatisfied with the disallowance and surcharge. The person has a right of appeal to the High Court. It is only on High Court. Oko High Court, na High Court, so only Judgement and Yaji, na disallowance near proper. So from there we appeal to the Court of Appeal. Now you do Court of Appeal, no? If you raise a constitutional matter at the Court of Appeal, say the Auditor General's power to surcharge and disallowance, no, and you're limited in scope. Back forth. When we made the prayer, the Court of Appeal agreed and referred the matter to the Supreme Court. That's one. Rakwame, so you say, me and me is an auto case in the man.
Sure,
So that time, Namia and Senior, Gary Nimako, a lawyer for the plaintiffs. And now, the rates are issue here. No, we will say relief one. The relief one, no. The way or drafting no, and or catching the relief one, no, or say the defendant within the meaning of Article 94(2)(c) is not qualified to be a member. Blah 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 blah. It is a way and say, Article 94(2)(c) relief one no eka about no. As far as I'm concerned, only kicks in if the Electoral Commission opens nominations. At the time, Omodia said no buy, no contention in say, when my client and a registered voter.
Yes, Ebeji Chiwapa Ghana.
Within the meaning of Article 94(2)(c). And I make a say that Article 94(2)(c) no only comes in if the Electoral Commission had opened nomination, and by that time she is not a registered voter, then she is bad. Okay, and now on for a Costo Gabra, President Rawlings are appointing the first time as minister. No, It came out said he was not a registered voter in 1992.
Yes.
And ministerial appointment was withdrawn until say 96 when a buyer 96 election a buyer or a registered voter and Sir President Rollins a year and the Minister of Education or Communication later.
Yeah.
Let me can say those constitutional provisions 94 only kicks in if nominations have been opened and the person is not qualified. But at the time, I'm senior Gary Eddie rate no buy, on behalf of the plaintiffs, Not only the NDC internal primaries had happened. And I'm saying no. If the issue is about being a registered voter, then there's an opportunity for limited registration. By which time she could have been registered before the Electoral Commission will open nominations.
It's a limited registration, but now one can register, dear.
And yes, I am no better no. And the call, I remember vividly, we had appeared, so the writ was before my Lord Justice Akabwafo. That I know a High Court judge, now a Supreme Court judge. It's the one I mean, yes, man can't crow. And I mean, raising preliminary legal objection. And I'm saying, my Lord, with respect, what's the really one of the plaintiff case now? Also within the minutes, it means that on the interpretation they are total. And I'm saying, my Lord, as far as Article 132 is concerned, you can't hear this matter. You must stay and refer it to the Supreme Court. And Article 132 is mandatory. It says, shall stay and refer. It make us, oh, my Lord, so the American, that is not it. As a High Court judge, Mankasa. So he gave a ruling on my application. One Abrakwame, the year Soshorarai. I invoke the supervisory jurisdiction of the Supreme Court. It means invoking the supervisory jurisdiction of the Supreme Court, no. In a Supreme Court by a 4-1 majority decision. Mekai Pa, my Lord Justice Eniobwa, at that time, dissented, but the remaining 4 agreed with me and referred the matter to themselves.
Court of Barton has not departed from
No.
their earlier ruling. Yeah.
That decision, that Senator decision today has set the rule on parliamentary election contest and qualification. It was even reported in the Supreme Court of Ghana law report.
Wow.
The reason why I'm bringing all of these instances, I want you to appreciate how the Constitution and how the lower courts have operated over time. Now, there's an interesting decision by the Supreme Court of Ghana.
Kabila.
It will show the case of the Kwabena Bonfe and Attorney General 2019-2021 Supreme Court law report. This is what the Supreme Court said. The real test as to whether there is an issue of constitutional interpretation is whether the words in the constitutional provisions the court is invited to interpret are ambiguous, imprecise, unclear, and cannot be applied unless interpreted. If it were otherwise, every conceivable case may originate in the Supreme Court by stretch of human ingenuity and the manipulation of language to raise a tangible constitutional question. Practically, every justiciable issue can be spun to such a way as to embrace some tangible constitutional interpretation. Indeed, the Supreme Court in this Kwabena Bonfe and Attorney General decision say, Sebio, a lawyer for you, very ingenious people. Omaji running very fast. Into 1 year, the Supreme Court will become the forum for every issue because at every point in time, lawyer need be a bit work.
When summer a course for political hearing, so if a chairman Wontumi lawyer, some attaching, summer what catch a high court and as Westiki at the Akoma High Court say anka mo san tu kyɛm a Wontumi ɛyɛ willing case no ɛyɛ de ɛmfa nhyɛ da ɛnyɛ ɛyɛ 20th ni bi anka Wontumi fa hyɛ da because otu kwan akɔhwɛ ayaresa abusua subscribe na subscribe na wahyɛ na wahit wɔ notification bell no so ama yɛ sɛ nsɛm bi ba political alliance wɔ na ɛde bi abɛdom yɛda mo ase.